Well, welcome. This is the Association of American Law Schools Teach-In webinar series on professional independence in the legal profession. My name is Austin Parrish, and I have the privilege of serving as one of the officers of the association. This six-part series is focused on issues related to professional independence. It features leading lawyers, academics, and distinguished speakers from around the country and abroad. It's open to students, staff, and faculty at nation's law schools, as well as lawyers at law firms and others in the legal community. For the students joining us, please be sure to check the series webpage for details about the writing competition associated with the series, which has a writing award associated with it, and also the digital certification for attending at least 5 of the 6 sessions. For the faculty attending, we encourage you to share the information about the series within your professional networks. We've had a fabulous 3 sessions so far. Today's series on professional independence in the Justice Department is being organized by Georgetown's Law Center on Ethics in the Legal Profession and Fordham University School of Law Center on Law and Ethics. We have 2 more programs coming up to complete the 6-part series. Next week will be At a Crossroads, U.S. Anti-Corruption Policy and the Changing Landscape of International Enforcement. That is being organized by Indiana University Bloomington's Maurer School of Law's Stewart Center on the Global Legal Profession. And then finally, we have the profession, the market, and the state, reimagining professional independence. That's organized by the Harvard Law Center on the legal profession and will be held on April the 27th. Recordings for the first 3 sessions in the series on executive orders and federal investigations involving law firms, principles for professional independence, and last week's Defending America's Independent Judiciary and the Rule of Law are now on the series webpage with a link posted in the chat. Before I turn it over to today's session, I wanted to let you know about a few upcoming association events that you may wish to attend or check out the recordings for a few events that took place earlier this month. So first, we have a Journal of Legal Education webinar, Crafting Scholarly Work on Legal Education, Insights from Leaders in the Field. That was held on April 9th. Recordings will be available later this week if you're interested in watching that webinar. Recordings for the ALS West Academic AI and Legal Education webinar series for the session, quote, Developing AI Literacy in Law Students was held in March, is now available on the series webpage. And the session AI Tools for Faculty was held earlier today, and a recording will be available in the next few days. I just wanted to mention 3 other key dates. First, we have our conference on clinical legal education that will be held from May 1st to 5th in Portland, Oregon. Usually close to 1,000 people attend that clinical legal education. I encourage you to join if you're interested. We also, on June 4th through 6th in Washington, D.C., will be holding the workshop for new law school teachers. And of course, we have the annual meeting that will occur in New York City this year from January 5th to January 8th, 2027. So thank you again for attending this session in the series. I look forward to seeing you at other events throughout the year. And with that, I'll turn this program over to Georgetown. Mitt, the floor is yours. Thank you so much for putting together what looks to be an absolutely fabulous panel.
Thank you, Austin, and our thanks to AALS for spearheading this. I'm going to say just a couple of words about our topic today and then introduce our discussants. The topic, obviously, is professional independence and the Justice Department. A crucial actor within the federal legal system is DOJ. It's a cabinet agency in the executive branch, headed by an attorney general, nominated by the president and confirmed by the Senate. And an important question is how much the department, as a cabinet agency, should follow the wishes of the president, and how much the lawyers in it, including the attorney general, should exercise independent legal judgment, even if it goes against the wishes of the president. And we have 2 wonderful scholars here with us today, Professor Bruce Green at Fordham Law School, Professor Rebecca Roiphe at New York Law School. They not only have done deep research on this issue, but they also bring to bear their experiences as prosecutors. So let me start first just by mentioning Bruce and Becky. It may surprise a lot of people to learn that the Department of Justice wasn't established until 1870, almost a century after the creation of the United States. Why was that? Why wasn't DOJ established at the same time as departments like State and Treasury that were created immediately after ratification of the Constitution?
Well, one of the main reasons is that criminal law enforcement was largely a state activity. The amount of federal criminal law was much, much less, and it concerned certain very distinct esoteric topics like maritime law. And so it wasn't considered, while the Attorney General was a cabinet position, it wasn't considered a kind of major federal endeavor in the same way as it is now. And also, even the Attorney General it wasn't clear that this was going to be a part of the executive until it sort of developed, in practice a few years after the founding. And so it took a long time before there was a felt need to kind of consolidate everything under the rubric of a Department of Justice.
Mm-hmm. And what was it that led to the creation of the department by 1870?
So I think there were numerous efforts leading up to 1870, and they all had to do with a felt need to create more efficiency, to create more uniformity and more professionalism within criminal law enforcement. There was some sense that everything was so diffuse that it was handled in this way that was a little bit haphazard, and that there were concerns about political patronage happening on the local level, these different district attorneys who really seemed to be answering to no one.
Mm-hmm. And it is interesting, I know from your scholarship, that people who could prosecute federal crimes could be state officials, they could be private parties as well. So, as you say, a very decentralized sort of process, right?
Exactly. It was decentralized in part, as a product of the way that the country was back then. It was just very hard to gather people together in one place, and everything was localized. And so there was a lack of uniformity in the law in that way as a product of the way the country was at the time.
Okay. And then now Congress is the body that creates executive departments and agencies, right? Was there any indication by Congress at the time the DOJ was created of the extent to which the department as an executive agency was supposed to be, just completely responsive to the president or maintain some independence of the president? Did Congress give any indication, any clues on that question?
The only indication it really gave was that its concerns were about the waste and inefficiency of the current system. I think there was very little concern that any president would kind of make any strong effort to exert control over the Department of Justice. That just wasn't what was on people's mind back then. So I think to the extent that Congress really thought about it, there's not much record of that. There was concern about political control, but it was really local political control to the extent that there was a concern at all.
Mm-hmm. Now, I know you've written about this. What does experience in the early decades after the Constitution provide for us in terms of any sort of clues about what expectations were in terms of relationship of prosecution of federal crimes and control or influence by the executive?
Yeah, I mean, there are certain instances in which, different presidents would assert control. Usually they were kinds of cases that had strong foreign policy implications. Again, federal criminal law was fairly limited. So to the extent that presidents were really doing anything, it was because there were implications that had to do with other areas in which presidents had responsibility, like foreign policy. But for the most part, attorneys general really did see themselves as distinct actors, responsive to the president in terms of policy objectives, but not taking orders from them for the most part, with a few exceptions in individual cases.
Okay, so we have, is it fair to say, sort of a mixed picture? Maybe some presidential involvement in some cases, and in other instances, not an effort to do that.
Yes. And some attorneys general strongly articulating something that sounds like a very modern notion of prosecutorial independence, and other attorneys general not really mentioning it or not seeing that as an important aspect of their job.
Interesting.
Am I right, Becky, in remembering that there was some thought very early about putting prosecution under the judiciary rather
Oh
than
yeah, so the early there were drafts of the act that created the Attorney General, the Judiciary Act, and the early drafts of that actually had the appointment coming from the judiciary. So it was not at all, in addition to having private prosecution and local prosecution, it also was not actually clear that it was going to be an executive function at all. So in the beginning, there was this sense that maybe this would be somebody who would be appointed by the judiciary, and it really was through practice that it ended up kind of falling under the rubric of the executive and kind of happenstance rather than a real plan to make this, a clear executive function.
Interesting. And Bruce, is there anything, I mean, obviously the Constitution couldn't refer specifically to the Department of Justice because it didn't exist at the time the Constitution was ratified, but are there any other provisions in the Constitution that might provide us any sort of clues about the role of the president vis-a-vis law enforcement and prosecution in particular?
Well, that's I think in part the courts have a role, which is why I raised the issue in that courts oversee prosecutors who are lawyers, and courts have a traditional role in overseeing the lawyers who appear before them. So that's I think even if you view this as a uniquely executive function, it's not really as exclusive as one might think. It's not exclusive the way, the war powers are. I'm not sure there's obviously the contemporary view of the court that, this is an executive power. It's vested in the president. The president has a responsibility under the Take Care Clause to, take care that the power is, faithfully used. But I don't know that at the inception there was, that clear understanding.
Okay. And there are obviously lots of different offices in the department that perform different functions. And you all have sort of written about the ways in which perhaps those functions and those roles might suggest different degrees of responsiveness to the executive and independence from the executive. Is that fair to say?
Yeah, I think, oh, sorry, go ahead, Bruce.
No, I would just, our focus has been on prosecutors. Becky has written a typology talking about a range of DOJ lawyers. They obviously defend the U.S. in civil cases. They bring civil regulatory enforcement actions. They give advice to the president. There's a lot of roles. But I think, I don't know what we're going to talk about today, but I think our focus has been on the criminal power.
Right. Yeah.
I mean, I just add, sort of jumping off from Bruce's last point about the Take Care Clause, that the Take Care Clause says that the president has an obligation to take care that the laws are faithfully executed. And scholars sometimes think, is this a grant of power? Like, is this something that gives the president the additional power, or is it a limit on his power? And my answer to that is it's both. And the way that the Department of Justice has been structured over time, it's to accommodate those two interests. That, in other words, he needs lawyers to carry out his policy objectives. Anybody does. And so that it's very important that these lawyers be responsive to the policy priorities of the elected president. But at the same time, that faithfully word is inserted in there. And that means that these lawyers also have an obligation to do something other than politics, other than just bringing out these policy goals. And that balance just plays so differently depending on what any given lawyer is doing within the Department of Justice. And I think at the very extreme is the point where Bruce and I write mostly, which is about prosecutors, where the independence is most important under those circumstances, because in order to faithfully execute the laws, prosecutors really cannot take politics into account in individual charging decisions. And so independence becomes extremely critical in ways in which there may be other lawyers in the Department of Justice where, in fact, being more responsive to the president and his policy objectives is a better balance.
Yes, and which makes a lot of sense. So it's very sort of role specific, and as you say, prosecutors are sort of on one end of that spectrum. Now it's interesting, we don't have specific constitutional text speaking directly to this, other than the take care clause, which I agree is both a grant of power and a limit on it, right? The early historical practice is mixed, right? So, and are there any laws? Are there any statutes that articulate what you just described in terms of the importance of the prosecutor exercising independent legal judgment?
You know, at the very least, there's the due process clause. And so, you know, if a defendant thinks that they're being prosecuted to serve the political objectives of the president, there's a claim that could be made about vindictive prosecution. Now, in the history of the galaxy, there haven't been a huge number of cases where defendants have been successful. But, you know, as the Ninth Circuit said in a case I don't remember the name of anymore, you know, you could have constitutional obligations that are not perfectly enforced. And so if a prosecutor were making charging decisions, you know, arbitrarily by throwing a dart or rolling the dice, it may be that a defendant can't, you know, vindicate the right to, you know, a non-arbitrary prosecution, but that doesn't mean that's a constitutional use of federal criminal prosecutorial power. And so I think, you know, implicit in the Bill of Rights is the idea that, you know, federal prosecution has to be used in a way, you know, that we've come to think of it, which is exercising discretion in a politically neutral way, taking account of things that are permissible and relevant and not irrelevant things. Now, obviously, you know, some irrelevant things like, you know, race, religion, gender, et cetera, if you could prove that that's the basis, you'd have an equal protection challenge. But, you know, politics is going to be often hard to prove, but it doesn't mean that that makes it okay for the president to, you know, prosecute foes and favor friends.
And of course, we have the take care clause, as Becky mentioned as well, faithfully execute, although we really don't have much jurisprudence on that as a limiting principle. But it sounds as though what you're saying, and I think from your writing this as well, is that prosecutorial independence is really a cornerstone of what we think of as the rule of law. Is that fair to say?
Yeah, absolutely. I think that's accurate. And I think, you know, the dangers of the dangers that come with its loss are not just individual. It's not just a loss of individual liberty, but rather a concern that you'll have a general chilling effect, that if people think that they can be prosecuted for their beliefs or because they take a particular position or because they oppose, you know, or they have unpopular beliefs, something like that, then you run into certain, you know, you would run into a clear problem that is with democratic principles that is beyond just the interest and liberty of the individual who's the subject of that particular unfair prosecution.
So I do feel like I should give a shout out to Robert Jackson, although he doesn't need it and he's not around anymore. But, you know, for people who write in this field, this speech he gave in around 1934, I think, when he was Attorney General, which he gave to the U.S. attorneys, is absolutely seminal. And it really does make this point. You know, I think he makes a point that the power that prosecutors have, you know, to destroy people's lives is, you know, second only to military power. And obviously, you know, as you say, it's about the rule of law. It's about using government power in a non-arbitrary way. We're a, you know, country of laws, not men. But these are laws that the people who implement them have a ton of discretion. And so as a matter of at least self-restraint and to a small degree, you know, constitutional restraint, that power has to be used in legitimate, you know, apolitical ways.
Mm-hmm.
Yeah, I mean, one of the things I think is really important to take from that speech is that this is you can't just say, you know, oh, well, if this happens, there's going to be a judicial response down the line. So you could have let's say, you know, okay, we haven't seen a lot of successful ones, but like, imagine a world in which courts were being perfect about figuring out when there's a political prosecution and making sure they throw out that indictment. That, I think, it's important to realize is not enough, because even if they were to be able to do that, the damage comes before that happens. And actually, the purpose of the prosecution is not even the successful prosecution. It is sending the message like, don't mess with me, or we can use this vast government power to come after you. And so that chilling could happen well before and regardless of what ultimately happens with a case down the line. So I think that's why prosecutorial independence is so important. We have a check on it, which might be the courts, but it's an imperfect check, and it's a check that comes too late.
Well, also the other side of the coin, although I think we would say that bringing investigations and charges against individuals which put them in fear and jeopardy is the worst evil. Using the power to favor friends. I mean, there's nothing you can do about the pardon power, but courts can't do anything about the decision not to go after people when the evidence suggests that they ought to be investigated and prosecuted. And you lose, obviously there's been a lot of discussion in recent years about weaponization. And to a large degree, that's about using criminal power allegedly to go after people who are, enemies of the person in power. But there's also favoritism and giving people a pass when, the evidence suggests that they should be prosecuted. And that was the theme of the Eric Adams case. We don't usually see it because it's kind of invisible if the Justice Department decides just not to open an investigation or not to present a case to the grand jury. But in this transitional moment, when you went from the Biden to the Trump, Justice Department, you had a prosecution that, from the Southern District's perspective, was a legitimate prosecution of the mayor of the city of New York for government corruption, and then it's being dropped, and it becomes a very visible moment where the issues that we're talking about now really come to the fore.
Yeah. And I mean, just going back to why we had the Department of Justice, it was specifically to combat that kind of political patronage. And so, if this is what's happening, it is certainly not consistent with what Congress intended for the Department of Justice.
Mm-hmm. So this is interesting because, as I said, if you're an originalist, there's not much material to work with. That is the text of the Constitution or what was happening around the founding. Indeed, it's at best a mixed record. You eventually have the creation of the department, but there appear to be just sort of implicit understandings of nature of the rule of law that sort of generate a set of expectations and norms. And you describe in some of your work the way in which those norms evolved and developed and crystallized. And I wonder if you could elaborate a little bit on that, because I think much of your focus has been the development of these expectations, even if they're not explicitly codified precisely in law, that nonetheless have a certain kind of moral force.
Yeah, I mean, I would say even beyond a moral force, they have a legal force, even if they're not codified, because we've defined them before as essentially a fiduciary obligation. So prosecutors have an obligation on behalf of the public to serve justice. And so that is a fiduciary obligation. And we think of fiduciary obligations as being legal obligations. It may be one that unlike traditional fiduciaries, is not elaborated by courts, but it is nonetheless, I think, not just moral, but also legal in that sense, in the same way that these understandings of what the content of one's duty of loyalty to one's client or to the beneficiary is not something that pops up fully made, but rather is developed over time. And that's exactly what has happened here. So that's why I think the historical reality of this leading up to and especially after Watergate is critical, not just because it tells us what our history and expectations and norms are, but rather what the legal expectation is from prosecutors.
So Watergate is often used as this seminal moment, and it certainly is, because it's the point where, after Watergate, when Ed Levy and then Griffin Bell were Attorney General, they made explicit the notion that the prosecutors can't take political direction from the White House. The White House can, the president can make policy, but isn't supposed to make decisions in individual criminal cases. But, somebody ought to do the history. I know Jed Sugarman has done historical work and others have, but, obviously, we talked about, Robert Jackson's speech in 1934 or so. And by then, I think there was an understanding about, the apolitical nature of federal criminal prosecutors. And even in the early, we've written about the progressive era and the movement from prosecutors who were in New York, who were under the control of Tammany Hall, to an independent prosecutor. And so, even by the early 20th century, while it wasn't, ubiquitous in state and federal prosecution, there were these understandings. And then I think, even you could go even further back, probably in the 19th century, and there'll be at least, judicial understandings that are maybe expressions of an ideal about, prosecutors' duty to do justice, meaning something other than carrying out the will of, an elected official.
Mm-hmm. Now, as you know, the Supreme Court in Trump versus United States in 2024 held the president is absolutely immune from criminal liability in carrying out any authority that the court described as conclusive and preclusive, on which no other branch can intrude. And the court said in this category is what it called exclusive authority and absolute discretion to decide which crimes to investigate and prosecute, right? So we now have a pronouncement from the Supreme Court on this issue. And how do we incorporate that into the understanding that you've described and the evolution of historical practice, assumptions, norms, which you suggest, in fact, have legal effect? Is there a way to reconcile what the court said and that sort of norm?
Do
you want to go first, or should I?
Well, I'll go first and say, first of all, I think there's more ambiguity in that opinion than than some people might, you read those words and it sounds so absolute and so complete. But if you look more carefully, I think that what the court really says is that it's an executive branch function, which itself was not, I think, as we were saying, necessarily clear to those of us who study this, that it was an exclusive executive branch function. But I don't think that they then go to the point, take the next leap and say the president then has full control over every single individual case. And I think there's room for some independence, even within what the court has said, because if the executive branch does, it doesn't necessarily say who then divides it up. I think there are other places in that opinion, and other places for sure in other opinions of the Supreme Court, where they've expressed a more extreme view of what we call the unitary executive, that if it is executive power, then it must be controlled entirely by the president. But I think we have not and do not know exactly how far the Supreme Court is going to go down that route. And I would argue that if they did take a strong view of that, of the unitary executive and president's control over individual prosecutions, that it would be almost incoherent. And so that an inappropriate and a misreading of the take care clause. So hopefully that won't happen.
So first of all, I just want to point out by way of footnote, I'm not sure who's listening to this, but these topics bring together, con law, criminal procedure, legal history, and legal ethics. And so I find this, at the very least, really interesting. But I was at your conference, Mitt, I don't know, like a couple of weeks ago on the rule of law, and sat at lunch next to Michael Dreban, who, was in the Solicitor General's office and argued on behalf of the United States, on behalf of the Independent Counsel, the Trump case. And I'm with Becky, and like my cup is, half full, and he was very gloomy. So I'm not, and he's obviously a constitutional scholar and is much closer to the issue. But to put it in the context of Trump against the United States, the only issue, and it's only 3 paragraphs that deal with this issue that you're quoting from. The issue was, the court held that Trump could not be prosecuted for his official acts, and then the question was, when he was talking to, high-ranking DOJ officials and about, the election fraud, arguable election fraud, was that an official act? And all the court really had to say was he had the power to fire those people. And so, talking to them was clearly, about, criminal or DOJ activity was an official act. And, the language about, preclusive and exclusive authority or whatever, it may signal something about where the Supreme Court is going, but they clearly were not facing the issue of whether a president can call up a prosecutor and say, present a case against Jim Comey or Letitia James or whatever. And so, I like to think that when they actually have to confront the issue, for the reasons Becky's talked about, they'll realize that this would be, not a great thing. And, but I don't think it certainly doesn't preclude the court from going one way or the other.
I mean,
Yes.
one of the things they say is that it would be, like part of the reason why they need to grant this immunity is because otherwise one president could then go after their predecessor, and that without this immunity, they'd be able to do this vengeful prosecution. And it's like, clearly they think the vengeful prosecution is wrong. So maybe they think, the only appropriate remedy, again, is a judicial remedy. And that just seems mistaken to me. But at least they're not saying this is absolutely fine. Any president has full control and they can do this. It would at least be an abuse of power. I worry about that because then the only repercussion, of course, would be impeachment, which is basically impossible. So, or political repercussions, and that may be where they're going. But again, I think there's definitely room in that opinion to at least think potentially otherwise.
Yeah, I think it's going to depend upon the extent to which they appreciate, going back to what we were talking about earlier, the take care clause as a limit on the president. And only in the last few years has there been really deep, rigorous scholarship on this. And it's pretty convincing, at least to me, that it was intended very much as a limit to impose, as you described it, Becky, fiduciary duties, on the president, and that members of the government hold offices in effect in trust for the public, right? We the people essentially are the author of the Constitution. So it's used take care clause, particularly in the removal cases, to say, well, the president has to have control over these subordinate executive officials to ensure that they faithfully execute the law. And I think they'll have to confront, the extent to which we need to think of that as a limit as well as a grant of power. Now, if we turn to the current administration, we've already alluded to that when we talked about the Eric Adams case. When Pam Bondi assumed the position of Attorney General, she issued a memo that set out expectations for lawyers in the department. And it said, in part, it is the job of an attorney privileged to serve in the Department of Justice to zealously defend the interests of the United States. Those interests and the overall policy of the United States are set by the nation's chief executive, who is vested by the Constitution with all executive power. Any attorney who, because of their personal political views or judgments, declines to sign a brief or appear in court, refuses to advance good faith arguments on behalf of the administration, otherwise delays or impedes the president's mission, will be subject to discipline and potential termination. What are your thoughts about the message that sends? Is that a relatively innocuous sort of statement of attorneys' responsibilities? I mean, the three of us teach professional responsibility, obviously. How do you, and of course, it's hard not to look at it with hindsight, but I'm curious how you regard that instruction.
I mean, I'll just say at first, I mean, even if you take some of her assumptions that I disagree with, every attorney owes their client a duty to represent that client diligently, but within the bounds of the law, even if you want to say zealously, within the bounds of the law. And so that's uncontroversial. So no matter what, even if you were to accept that the president gets to set every, agenda and every, for every criminal prosecution, which I don't, no matter what, a lawyer for that client has to act within the bounds of the law. That's the first problem. And then the second problem is really that I don't think that's accurate. I don't think that a prosecutor's client is not the president. A prosecutor's client is the United States. And the United States is specifically the United States' interest in justice, which cannot always be determined by the president because, quite frankly, take the Eric Adams case. Sometimes the president's, even if it's not his personal interest, his interest as president is in bringing about his policy objectives. So he wants his immigration policy to be the best ever, right? The most effective. But if that involves jailing everybody who comes into his, who crosses his path, then that's an inappropriate thing for a prosecutor to do, unless those people have actually committed crimes and it would be worthwhile otherwise to prosecute them. So to me, it seems like it cannot be that the president determines what happens within every individual case, because otherwise there is this essential kind of conflict in the duty to their client, which is the president has the duty to bring about their policy objectives, but it's the prosecutor who has the duty to make sure that the laws are impartially executed, the criminal laws are impartially executed, and you can't do both at the same time.
Well, the statement to me is a little incoherent in the sense that it's not clear which DOJ lawyers it's talking about. So when I first read it, I would not have thought about prosecutors. I would have thought about civil litigators who are called on to defend the constitutionality of the things that the president of the executive branch are doing, executive orders or other things. And so that notion that you have to make be able to make a good faith argument slightly makes more sense in that context, because as a legal ethics matter, as long as you're not making frivolous arguments, you're home free. And so you're allowed on behalf of, say an individual who's a client, if they feel like they want to defend something that you think is stupid and barely defensible, you can do it if it's a good faith non-frivolous argument. Whereas if you're a prosecutor, I don't know what that means exactly, because there's an internal long-time understanding you don't bring prosecutions unless you believe the person's guilty and you believe it's a triable, potentially winnable case. And so if you're talking about presidential policy, yes, presidents get to make criminal justice policy. We're going to spend more resources on immigration law and less on something else. We're going to, focus investigation resources on election fraud. President Obama wrote a piece in the Harvard Law Review about, the president and criminal law, and I don't think anyone dispute that the president can make policy in a general sense, but not to, throw a dart at someone and say, bring an action against them. And so the problem you had that led to resignations, I think, or firings of career prosecutors in the Letitia James and Jim Comey cases is bringing the prosecution against them would have been at odds. Maybe you could make a good faith argument, whatever that means, but you certainly it would be at odds with the conventional understanding that you don't go after people if you don't think they're guilty. And the prosecutors didn't, whatever investigation looked at the evidence, and they didn't think these people were guilty. And so they were essentially being asked to do something that we would say is a breach of fiduciary duty. It's not lawful for the prosecutor to do that, given conventional understandings of how prosecutors use their power on behalf of the client, which is the government.
Well, you mentioned the standards that guide prosecutors. Actually, it may be worth, I think, elaborating a little bit on that, because first of all, there are rules of professional conduct promulgated ultimately and approved by the highest court in each state or jurisdiction. But then there are rules, first of all, that relate specifically to prosecutors. And then there are policies or manuals that prosecution offices adopt. Could you elaborate a little bit on how it is that prosecutors are expected to exercise this pretty considerable discretion?
Yeah, so I think for the legal ethicists out there, they know that there's a provision in the Rules of Professional Conduct 3.8a that is much more forgiving. It says, you can't bring prosecution, can't bring charges unless there's probable cause, which is a pretty low standard. And if you get a grand jury to indict under a probable cause standard, then I guess you're home free. Not every prosecutor's office would agree that you should have a more demanding standard as a matter of self-regulation. But I think, where I worked in the, DOJ in the Southern District of New York, and where Becky worked in the Manhattan District Attorney's Office, that was the understanding that you would not bring a case unless you were personally convinced, of guilt beyond a reasonable doubt, unless you can try the case, because otherwise, there's too great a risk that you may, because you're a skilled lawyer or the defense is not that skilled, or for other reasons, you may convict an innocent person. And so you have a gatekeeping responsibility, or you may not convict the person, but you're basically torturing someone who, is not guilty beyond a reasonable doubt. Now, but that's a matter of self-restraint. So it may be reflected in, internal, the U.S. Attorney's Manual, internal self-regulation of the Justice Department. You could wipe that away in a day. If Todd Blanche wants to, get rid of that understanding and say we should feel free to go after anybody as long as there's probable cause, he can do that. So that's, but that's he hasn't done it yet, as far as I know.
I mean, I think, to answer or to add to what Bruce just said, I think that this settled understanding is that prosecutors are serving the public's interest in justice. And what that means is not as easy to codify as you might think. And so it's kind of like, it is like many fiduciary obligations, therefore elaborated through the expertise and experience of the people who've had these jobs, and through internal policies and through terms of rules and all of these things together. But whatever it is, I think it is quite clear that all of those things are going toward this elaboration of who your client is and what your client's abstract interest is that you are supposed to be pursuing. And the Supreme Court has said that. I mean, that is not a controversial point. So this notion that at any given moment, the president could just say, no, what is in the interest of justice is what I say because I'm the elected president, is radical. I mean, if the Supreme Court adopts that, that's radical. That is absolutely inconsistent with the way that any prosecutor has approached their job, up until potentially a few prosecutors recently, because that point has never, or just isn't really in contention, and until recently, maybe.
Even the rhetoric now doesn't go that far. I mean, what they say is, the Biden administration prosecutors weaponize their power. And so they fire every prosecutor and FBI agent who had anything remotely to do with the January 6th prosecutions, notwithstanding that not only did grand juries indict on a probable cause standard, but juries convicted on a reasonable doubt standard unanimously in an adversarial proceeding. So he's not, I don't think the DOJ at least is willing to say at this point, the president can call the shots and we're just an appendage, or as Dan Richmond at Columbia said, a sock puppet of the president.
Well, right. And I mean, that's another thing, is it's not in the president's political advantage to make that point clear, because what he wants to say is, these people are being prosecuted. They're my political enemies, and they're being prosecuted because it's a righteous prosecution, not because I ordered it, because he doesn't want to seem like he's a dictator. He wants to seem like everything that is just happens to be completely and 100% aligned with what his interest is. So this undermines the sort of unitary executive point, which is that the whole idea behind the unitary executive is it helps create political accountability, so that if you don't like what the president is doing, you can vote him out. right? And we don't like all these unaccountable bureaucrats running around. But the fact is, it doesn't help political accountability, not at all, because we don't even clearly know when it's happening and when it isn't. And so if the president were just to declare, I've taken over the Department of Justice and now it's doing what I want, which he sometimes seems to do, but as Bruce said, it hasn't, then at least the voting public could say, I either like that or I don't like it. But he's still hiding behind this notion of prosecutorial independence. So it's very unclear how is he going to be held accountable for this if he's hedging in this particular way, and there's no obligation to be transparent about this point.
As we all know, the president recently terminated Pam Bondi as Attorney General. So this might be a good point which to maybe take stock. What's your assessment of her tenure as Attorney General, but with respect to the state of the department as it now stands?
Well, first of all, the fact that so many people left is telling, in my view, that people who'd grown up as prosecutors and government lawyers in general in a culture that for decades, valued, the independence of the lawyers and an obligation to seek justice, felt that they couldn't do it anymore. And then, the memos, like you referred to one, but a number of memos she issued that sort of convey the idea that we're an arm of the president, he's the client in some personal way, I think, is awful. And then, we've seen these cases where it seems so clearly, maybe because the prosecutions follow a social media post on Truth Social, where, it seems like that office is going after political enemies of the president and not, where career prosecutors are refusing to aid and abet that. I mean, so I wouldn't, I don't know, is there a grade lower than an F? I wouldn't give it high marks.
I mean, I would say one thing, which is we talked about Watergate and the Saturday Night Massacre earlier. I don't know if everybody knows what that was, but essentially President Nixon tried to fire his attorney generals because they wouldn't slow down the investigation into Watergate. Specifically, the special counsel was asking for these tapes and he wanted the special counsel fired, and these attorney generals wouldn't do it. So he fired them. So this was like a come to Jesus moment for the country, but just note the difference, which is back then, the attorneys general were still trying to serve as a buffer zone to prevent this kind of political interference into the Department of Justice. It was the effort that was scandalous. And now we have a situation when it really looks like the attorney general does not see that as part of her role. She sees herself as his attorney, like his Roy Cohn, his sort of aggressive litigator attorney who is trying to get everything that he wants done, getting his lawyers to do everything that he wants, including his prosecutors. And that, it depends on, if your view is we need to have a very powerful executive who can use their lawyers to do this, then I guess the grade would be higher than an F. To me, it seems like that is clearly not the intention of Congress when they created the Department of Justice, nor just it fitting in the structure of a democracy. So it seems extremely problematic.
So just to bring this back to legal ethics, we had a brief foray into like agency law a while back also. I would note that there are a number of, not-for-profit, probably not the most nonpartisan groups that have been filing disciplinary, complaints against folks in the Justice Department, including Pam Bondi. And the complaint against her was filed in Florida, which is where she's barred. And the Florida Disciplinary Authority said, under Florida law, we don't go after sitting public officials, but she's no longer a sitting public official. And so presumably they'll have to maybe look closer at the merits of that complaint. And part of the rationale, I think, is as a lawyer, she has supervisory responsibilities. And so you have Becky and I focus on prosecution, but if you look, a lot of the action has been on the civil side in immigration cases, for example, and you've had many cases where judges who seem incredibly patient have found that the government is violating court orders and that the lawyers are making misstatements or concealing information. And I think in general, federal judges think very highly of government lawyers and tend to assume that if there's violations, it's inadvertent or unwitting or whatever. But I do think the number of those cases, which may number over 100, suggests that among her failures, at the very least, was a supervisory deficiency.
Mm-hmm. Yeah. One question, I think, for a lot of people is accountability. The Supreme Court, sort of, and to the extent that it embraces the unitary theory of the executive, has said things like the president is the only government official elected by the entire country, right? And somehow that makes him or her, accountable. But with these prosecutions, for instance, I mean, obviously, you have the possibility that a grand jury won't return an indictment, right? But they have returned indictments in some cases, right? With Letitia James, for instance. That can be dismissed for vindictive prosecution, or in that particular case, because the putative U.S. attorney wasn't lawfully appointed. But what other sort of mechanisms are there? I mean, the president does not seem to be slowing down in his determination to go after as many people as possible. Indeed, one of the things that prompted his termination of Pam Bondi was that she wasn't aggressive enough. Right? And so you can say that these prosecutors are not fulfilling their professional responsibility to do justice, right? But as a practical matter, I mean, does this suggest that these norms are actually quite fragile and really ultimately depend upon those who are in office in these positions working in good faith?
I mean, I think we're learning that democracy itself is made up of a lot of different parts of sort of fabrics. And one of those fabrics is just norms of respect and understanding about the basic structure of democratic government. And without those, things look a lot more fragile. So I think just like everything, yes, that in some ways that with when people are willing to just dispense with these norms, that that is a lot. But but I don't think we're without tools, and I think courts really should start stepping up. And Bruce and I have written about this in certain places, that courts could be more active in policing these breaches than they are right now, and that they really should be, because they are in a better position, we think, than, for the most part, usually, than state regulators to at least take the first make the first effort at holding lawyers accountable when they've done something that's clearly wrong.
So I feel like your question, Mitt, raises the issue of accountable for what and to whom.
Yeah.
So, on the issue of whether prosecutors can be sued civilly under the civil rights laws, the Supreme Court said in Immel against Packman, we're not going to make them susceptible to lawsuit because that would be chilling, but that's okay because they're lawyers and they're susceptible to professional discipline. So if you're talking about accountable for complying with conventional norms, then that's an answer, to say nothing of they're being supervised by other higher up people in justice. But your question also raises sort of accountability politically to the president. So if the question is, what can you do about prosecutors who are not doing what the president wants? We don't want them to do it. Becky and I, at least, don't want them to do what the president wants. But the president can fire the AG, as he did, and the AG can fire subordinate prosecutors. But we want to protect them. I mean, one of the things that I think is maybe on the chopping block is civil service protection. And so, if you like the idea that prosecutors need to be independent to say we're not going to do bad things that violate our fiduciary obligations to seek justice, you want them to not be able to be fired absent cause, and you want the civil service law. But I suppose if you take a strong view of the unitary executive theory, then that goes out the window also.
Right, and we've seen instances of that. You know, Maureen Comey, Jim Comey's daughter, a prosecutor in the Southern District in New York, fired notwithstanding civil service protections. And the reason given for her termination on the notice was Article 2 of the Constitution. And the Office of Personnel Management has a final rule now that basically strips civil service protection from a number of federal employees on the ground that they're providing policy advice. And there is concern that that's going to be extended to prosecutors as well because of the discretion that they exercise, right? So that would be, you know, further sort of ways of exercising influence. Let me close with just a final question. We're talking about professional discipline, which is exercised by the particular bar, the state or DC in which an attorney is licensed. The Department of Justice has a proposed rule under which if there is a complaint against, or an allegation, I should say, against someone in the Department of Justice, the Attorney General first reviews that in consultation with the Office of Professional Responsibility at DOJ, and they are requesting that any state disciplinary authority suspend any investigation until that's done. And if they don't do that, there is language that says that the department will take appropriate action to enforce the regulation or prevent bar disciplinary authorities from interfering with the Attorney General's view of the allegations. What are your thoughts on that? So one might say, well, you know, the Justice Department has a good idea of what's expected of lawyers in the department, so it makes sense for their Office of Professional Responsibility because it's specialized, you know, to review this first. What are your thoughts on this proposed rule?
Can we put in a plug for the article that was just published this week in Lawfare with our
Yes,
views?
we can. Please feel free. No, I do actually. Yeah. So you have a piece. Go ahead.
Yeah, Becky, go ahead.
To quickly summarize the piece, essentially, we think that that regulation is both unenforceable and unwise, in part because it seems like a pretty bald effort to try to insulate federal prosecutors and federal government lawyers in general from any kind of accountability. But that said, you know, there are real issues with the way that regulation is structured. And this is not a new problem. This is a problem that has stretched from, you know, across Democratic and Republican administrations over a long period of time. There've been these sort of struggles that represent real problems because there are reasons why state regulators often and in part ought to let others take the lead. But we argue in this article, just spoiler alert, that that we think federal courts are the ones who should really step in here because it's an outside party. So it's not fully self-interested regulation, which means no regulation. And they're less likely to interfere with sort of federal criminal law enforcement priorities in a way that would be kind of deemed problematic.
Well, this has been a terrific discussion. Thank you so much for your insights, as always. And this is an issue, obviously, that's going to be ongoing. We are seeing a president who's very determined to exercise control over the Justice Department and over prosecutions in particular. And so I think we're going to see just what sort of measures there are for constraining that and defining exactly what the scope of executive influence appropriately is. So thank you very much. Thank you as well to the audience. I would commend you to look at the scholarship of Professor Roiphe at New York Law School, Professor Green at Fordham, because it's very insightful on these issues. And so thank you for joining us, everyone, and have a good evening or afternoon, depending on where you are.
Thank you so much.
Okay. Bye now.